Their ears. Are people in the back able to hear? Yes, okay. All right. Thank you both. If you'd approach. I'll now call our second case for submission today, PD-0135-25 and 01326. Jaimes, I believe, versus State of Texas. I believe we'll hear first from counsel for the state.
May it please the court, counsel? My name is Johnson-Liu, arguing on behalf of the state. The whole point of this area of the law is to ensure that the jury charge conveys to the jury the culpamental state requirement. That is specifically in terms of the elements of the offense. What does the defendant intend, know, or risk? And this jury charge did that. Cook, on the other hand, should be overruled because it's really a myth that these untailored, abstract categories, nature, circumstance, result, things that attorneys argue over, that could ever trump concrete instructions that leave no doubt what the jury should determine.
Well, if lawyers would argue about it, wouldn't jurors potentially argue about it when they go back to deliberate?
Because there are arguments like in this case, intent to arouse or gratify, is that a result or is that a nature? Because there are arguments, then it's not going to cause problems for the jury because there's ways to have meaning for both of those things. The jury charge ultimately was not erroneous in this case. It's only because of Cook that it introduces the idea that misconceptions on various levels could create error in the charge. But that premise is wrong because there are so many missteps that a jury would have to take before there is a misconception about that abstract instruction on intent and knowledge. So it is, and that's why we've asked for this test. Overrule Cook, and in its place, ask, does the jury charge leave no doubt in ordinary English grammar terms, what does the mental state require them to know, to intend? And if the jury charge does that, then there is no need for tailoring because the tailoring has been done in the application paragraph when it conveys what in the specific terms of the elements of the offense does the defendant have to intend or know or risk.
It sounds very similar to what Judge Campbell said in dissenting, and so it's compelling that this is an idea that has been around for a while. I'm wondering about, I'm going back to sort of first principles on these things, and the way we construct jury charges in the modern era is we follow some formulas, that we've got the Texas pattern jury charge, Texas State Bar pattern jury charge. I know you're familiar with that. McClung's. Everybody's got these treatises that they rely on to try to figure out how to construct jury charges. And so they do so in a manner that typically, almost traditionally now in the state, everywhere you look, they have an abstract definitions kind of part of the charge followed by an actual application paragraph that then guides the resolution. And I'm wondering is there any, the statutes that I'm aware of say that the court shall instruct the jury on the law applicable to the case. And it doesn't really say by giving an application paragraph and by giving a abstract definitions portion. And so when you have this difference between abstract definitions and then application paragraph, what does that speak to? I mean, is there any statutory rules that guide the way we separate that out that would tell us what it means to have abstract definitions? Sorry, I know it's very deep, but
there's not any statute that would say that.
Yeah.
It's more development in the case law.
Okay.
And, like sometimes you got to drill down and tell the jurors for this case, for this offense, what are we talking about? Mm-hmm. And I think it's a common sense idea that that's what they understand.
Well, if we were going to overrule Cook, then shouldn't we put something better in place? I mean, the idea that we call this thing a charge, but it seems to me, forgive me for being blunt about this, but what you're suggesting is this really isn't a charge if we overrule Cook and do it your way. It's more like random thoughts on the law followed by questions that matter. Right, because if we have errors in the document, in the abstract, if something that's in there that would be inapplicable to the case and incorrect to the questions that are going to be asked, we would just ignore it, right?
Well, it's not error, and it's not necessarily inapplicable. So whether something is nature or result, like the intent definition here, intent to arouse or gratify, the definition says for intent, to the extent it's nature, it's to engage in the conduct. To the extent it is result.
But the judge isn't answering that in the charge, right? You're just saying it's just there. And the jurors are going to go back into the jury room to deliberate, and each side is going to be armed with their own view of the case, and then they'll be pointing to the parts of the charge that they like, right? That's what jurors do.
Jurors are going to point to the parts of the charge that has meaning for them, and that is most likely going to be things that are applied, things that are in terms of the elements of the offense or about the trial that they're talking about. I doubt very seriously they're pointing to those sections of the definitions of intent and knowledge. Now,
do you know are there any other cases in which our court has required the tailoring of a definition to be given to the jury in the abstract portion of the jury charge? I mean, I know that Cook and Alvarado and some of these cases that say that you need to tailor it for mental state definitions, right? Have we ever said that you have to tailor other definitions that might appear throughout the code? Because there are a lot of definitions that say either this or that or the other thing could be the thing that's being defined. And I've been racking my brain trying to think, is there another type of a definition that we say, oh, you can't include that part, you got to be really smart and strike that part out because it's technically not applicable, and we don't seem to wrestle over those things.
the only thing I would want to look up is maybe for intoxication, where you have the theory of intoxication possibly, that could derail them.
Okay.
I feel like that's different here because anytime you have if you have the application paragraph and it has terms and it's sending you over to the definitions section in the abstract, like when those things are limiting or expanding on what is really a matter for the application paragraph, that could conceivably be a problem, like the theory of intoxication. But here, what you're really expanding it to is not even expansion first, because strictly read, these definitions say to the extent it is nature, to the extent it is result. Okay, but even if you get beyond that, then it's not a broadening in the same terms as in the application paragraph, in terms of what are the elements of the offense. The expansion, to the extent there is one, is to abstract ideas that are not ever connected up with anything else. And that's why I think the premise of Cook is wrong, that they are saying jurors will necessarily grab onto one of these options. It will be the wrong one. They will distill from nature, result, and circumstance these ideas that are actually elements in the case. And then in contradiction to clear language that says you have to have the intent to arouse or gratify, they think, oh, you don't have to have the intent to arouse or gratify because I think that is a result and I'm gonna grab onto the engage in conduct language. Like there's so many levels of missteps that have to happen before there is error.
Counsel, let me ask you something. There's a lot of missteps, but I just want to focus very narrowly. Would it have been correct in this case for this jury to convict Appellee without proof beyond a reasonable doubt of the intent to arouse or gratify the sexual desire of any person?
That was required.
Okay, so if the intent to arouse is required to be proven beyond a reasonable doubt, then why is it appropriate to put this result of conduct or no that has the potential, a very real potential of confusing the jury between the narrow focus of intent to arouse versus the result of the conduct or knowing that it might arouse? Or why is it appropriate to have that in, whether it be application or abstract? Why is that appropriate?
Attorneys cannot even decide whether intent to arouse or gratify is result or nature. That's why it's not going to be error in the charge. That's not going to be a misjudgment.
Doesn't that speak to confusing the jury? If the attorneys can't figure out, how can we expect lay people to figure it out? Why would we want to confuse them away from the narrow focus of intent to arouse or gratify?
There may be better ways of charging the jury. It's better to sidestep nature, circumstance, result altogether, to tell them just in plain language what the elements of the offense are. But Cook says, doesn't really allow for that.
I think that's what Judge Uri is looking for. I'm right there with him. If we're going to replace Cook, can we replace it with something that resembles a professional fact determination process in a professional judiciary? Other than, well, just, there's stuff in there that doesn't matter, but we assume the juror's not going to really pay any attention to it when they enter a jury. So, what I'm looking for is, from you, is something that's better.
So I don't think that the legislature mandates that 603 definitions be in the jury charge. These are definitions, they are in the penal code, but the purpose of those is when we do not know what the mental state goes to. These definitions help us figure that out. To the extent we identify something is the nature of conduct, then that's, the intent could go to that. But when you've already determined what the mental state goes to, then there's no real benefit in deciding that, okay? And there are two different categories of times when we're gonna know what is clear. One of those is a specific intent to arouse or gratify. That cannot be plainer what the mental state goes to, right? It's spelled out. Or specific knowledge, same thing. Or you have intentionally or knowingly cause bodily injury, where the mental state is directly followed by the money element, the thing that the jury has to find. In that instance, the jury charge is already going to be perfectly clear. In those instances, the intent, knowledge, recklessness definitions really do not aid. To the extent that you want to be helpful and grab some content out of those definitions, then I think it's intent means conscious or objective or desire. Knowledge means awareness. You'd have to play with, I don't have a quick thing for recklessness, but I think that's where overruling Cook would allow this sort of innovation. To instead of striking out certain words from the legislature's definitions, then we could only give them definitions that would make sense to common people. Or you tell them like the state bar pattern jury charge. You tell them, not in terms of nature, result, and circumstance, but you tell them a person acts intentionally, if you intend bodily injury and you cause serious bodily injury, you know, put it in the application paragraph or the list of elements that way. So there are ways that we can convey this information, but I think Cook is standing in the way of that. And even in the criminal, the state bar pattern jury charges, which does it better, there are judges who are resistant to the idea of using that better way because Cook says you strike through different parts of that 603 definition. And so in the citations that I've mentioned from the capital jury charges show this, that sort of a mishmash between the pattern charge plus 603 limited definitions under Cook. So it's our position that untailored abstract categories, this nature, circumstance, result, never alone are causing problems. The missteps that might happen, because there's like 4 levels of them, can only become a problem if you've got an attorney that is directing them to that part of the definition saying use this. The jurors on their own don't grab these abstract concepts and try to apply them. And if it's really an argument problem, then take care of it by objecting an argument. The other source is where the charge itself does not clearly convey what the mental state is, because you don't have a specific intent, or the money element doesn't directly follow from the intentional or knowingly mental state.
If we don't assume that the jurors are going to pay attention to what's stated in the abstract, why would we assume they listen to the lawyers? Those words came from the judge first, right?
Yes. I mean, It depends.
If
Like,
we follow your argument, we should just say, yeah, they know better. They get back there, they know to file the,
often you have it
application.
throughout trial, through voir dire. I mean, and here is a perfect example of where the parties they were not talking about Cook. They were not focused on, hyper-technical categories of abstract things. They were talking about the elements of the offense and what the mental state of the defendant was. And jurors can follow that because they're listening to people who are trying to talk to people.
I have a question. So I think there are some differing views on the court here that we've expressed in opinions about stare decisis, right? And about like when to follow it, when not to follow it. And one of the factors, even under the traditional application of that doctrine, is whether a rule is unworkable, right? Or whether it causes problems. And so I was wondering, I don't know if you have any statistics or anything, like since we decided Cook, how many times our people they argued that, hey, the trial judge messed this case up because he or she, struck the wrong things from the definition? Have we created a cottage industry for error that isn't really error? What could we look to try to discover that?
Okay, so my only kind of go-to is if you look on just do a Westlaw search, and you compare the number of Texas cases on this issue to any other state. And you have like 3 or 4 or 5 other cases in other states.
Yeah.
We have hundreds of cases, and so it really is an issue for appeal.
but that just could be what you would call a coincidental effect of the importance of the jury charge and the outcome of a case, right? I mean, whatever case, if we write this case saying every jury charge that comes close enough is good enough, and I'm not saying anyone's suggesting that, but it's gonna get cited a lot, right? Whatever the current law is on the jury charge is gonna get cited a lot.
It will, but this is an unusual type of claim. It's an unusual error because, strictly speaking, the instruction is correct, and these are the legislature's definitions. It's an unusual circumstance to say this is error. And so to glam onto that narrow kind of unusual circumstance and have it be repeated hundreds of times is odd.
Counsel, I have one very brief question. In this case, in this jury charge, it said, a person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct. Could not a jury look at that and say, okay, it was his intent, her intent to engage in the conduct, wrestling around. And this says that if it's his intent to engage in the conduct, then they act with the intent to the result of the conduct. Doesn't that impermissibly merge, especially in this indecency with the child aspect, where it's a nature of offense requiring an intent to gratify? Doesn't that allow the jury to say, well, she may not have intended to gratify, but she intended to wrestle, and this says that the result of the conduct, somebody was gratified, means that's intent. Doesn't that just impermissibly allow the jury to convict without finding intent to gratify?
So there are 3 different parts of this charge. One, the abstract definition of the offense, and it says you have to have the intent to arouse or gratify. 3 says in the application, the defendant did in there with intent to arouse or gratify. I don't see how, with those plain terms, why would a jury grab onto the wrong thing, seize onto the wrong one, and then abstract it out into...
Why would we have the wrong thing there at all for them to grab onto?
These are the legislature's definitions. There is a better way of doing it, but this is not it.
Just before you go, there's nothing stopping us from grabbing a hold of this then and fixing it if we can find a way to fix it.
Yes.
Not creating a conflict with another branch.
That's right. I think there are probably multiple ways of doing it.
Your Honor, may it please the court, I'm John Bennett. I'm representing Yocelin Perez Jaimes today. Counsel? Your Honor, leaving the Cook question aside for just a minute, if I may pose a hypothetical. Every so often, I'm asked to write a PDR for somebody I didn't represent at the Court of Appeals. Say the Court of Appeals was presented with only the question of this juror should have been excused and wasn't. The Court of Appeals said, no, the juror vacillated, trial court was within its discretion, that's all. If I filed a PDR saying, oh, yes, but the state's jury argument was extremely wrong, so you all should reverse it on a theory that was never presented to the Court of Appeals, that PDR goes in the trash, and rightly so, because the rules, the justifications for PDR being granted in Rule 66.3 can't be applied because the Court of Appeals never was presented with the question and never passed on it. Well, Your Honors, here the state is saying, we, the state, created the jury charge. So we think it's correct. In the Court of Appeals, the state said, actually, no, it wasn't correct, but you should affirm anyway. The court reversed. Here the state is saying, oh, no. It wasn't correct, but for a theory that wasn't raised in the Court of Appeals. If attacks on Cook are to be taken seriously, with all due respect, this is not the case to do it.
Well, I mean, the state couldn't ask the Court of Appeals to overrule Cook, could they? I mean, they would be asking the Court of Appeals to overrule our court, and our court's the high court of the state. So isn't the state kind of stuck with our jurisprudence when they're in the courts below?
Of course it is, Your Honor. And I'm here to help Ms. Jaimes Perez entirely. However, privately, Your Honors, I beg you to accept the state's argument in this. The state is saying, well, the Court of Appeals wasn't swayed by this, although it was to some extent because it said there was error. But the Court of Appeals couldn't have overruled Cook anyway. And anyway, it was their appeal, not ours. I think of all the lovely Meridian Category 3 errors that I could raise if you accepted the state's argument, saying, oh, well, the trial court couldn't have changed the law and wouldn't have accepted the objection. And anyway, it was the state who brought the charges to this court, not me. I beg you to reject, in another case, to accept that argument.
Not on behalf of your client.
Not on behalf of my client. I'm representing Ms. Jaimes alone today.
Can I ask a question that
Yes,
kind of
yes,
like, so I like to kind of move around and see how things that litigants ask us to do, how they might apply in other circumstances. And one of the things I came across was the definition of insanity, okay? The definition of insanity says, and typically that's something raised by the defendant, not
Yes.
by the state. And so it says it's an affirmative defense to prosecution if the time of the conduct charge, the actor, as a result of severe mental disease or defect, did not know that his conduct was wrong. Now, when I read that, I thought, well, I'm wondering, what is a disease? What is a defect? I'm not sure, but surely actually it goes on to explain a little bit more in the next section. But if the state came along and said, well, all that was testified to was that he had schizophrenia, for example. Well, what is that? Is it a disease or a defect? So the state could say, well, we think it's just a disease, and so we don't want you to have defect in this charge. Would the defense say, what would the defense's argument be about the defect? Whether it was a defect, would you want that included? Would you not want that included on behalf of your client? For the jury to consider that term?
I'm no trial attorney, but I think I wouldn't want it included. Schizophrenia is, the schizophrenic brain doesn't look like everybody else's. That is a disease, I think. It may be a defect too, but the word disease carries more meaning.
So sometimes these alternative definitions have, different people look at them in different ways, And so what I'm thinking is, it's sort of good for the goose, good for the gander thing, If we have this precedent, Cook, that's been around for a while, and it says, hey, you need to tailor all these instructions. Well, if we continue to affirm that, at some point are we going to have to start tailoring everything, and are we going to create this bigger cottage industry of every time you apply any definition of any kind, you better strike every single thing that's not applicable, or else it's error, trial court judge. And by the way, are we going to even be able to assume that the trial court judges are going to be capable of making all those assessments in every case when they've got 50 jury trials a year? Is that reasonable?
I don't think it's reasonable, Your Honor, but I think it's a minor touch compared to what's going to happen if you overrule Cook, which found its justification for tailoring in Alvarado.
Right.
If you overrule that, that is 40 years of precedent. Alvarado was 1985. That's between a quarter and a fifth of the time that Texas has actually been a state. The precedent, attorneys will have learned Cook and Alvarado in law school. They'll have been using it all their lives. Hundreds and hundreds of cases from this court and the courts of appeals have used Cook, have pointed to Cook.
Counsel, is Cook unworkable?
I think it's workable, Your Honor. And if it's not workable, sorry, DeSantis should take care of the problem. We got 40 years of this. I think it's workable because it says, look, you must take out this language and that language. The state's reply brief and its original brief says, it creates a lot of work for the judge and other people. What work? In a trial, the trial judge looks at the charge, the proposed charge, asks if there are any objections, and that's usually it. He has to rule on he or she has to rule on the objections.
It is the judge's charge, right?
Beg pardon?
It is the judge's charge.
It is the judge's charge, yes, but if there are no,
Proposed it.
if the judge rules on any objections, it becomes the judge's charge, yes.
Well, isn't it kind of hard sometimes until this court has said so to say what kind of an offense, what the conduct element is, whether it's nature, circumstances, result? I mean, it's not really spelled out all the time, right? Isn't
No,
that where the difficulty comes in?
I don't think so, Your Honor. It's a definitive thing. It says what needs to happen. If it doesn't happen, it's error. The defendant should be preserving the error, of course, but it is error.
And
It's,
there was an objection here, right?
yes, Your Honor.
And
Both-
so, let me ask you about that, the harmfulness of the application paragraph versus the abstract definitions. I'm looking at the application paragraph, and it doesn't seem to adopt anything other than result of conduct.
Yes,
So
that's the
how
key phrase.
could the jury have been misled by this application paragraph, even in light of the abstract definition?
The jury, in saying, excuse me, may I?
Yes,
Yes, sir. Of course.
Take your time.
I'll join you.
We call that,
Take your time. Don't worry, you're doing great.
The jury was told, you can convict based on the nature of the conduct or the result of the conduct.
It wasn't told that. It was said, I mean, they defined intentionally and knowingly in all of that, in all of those terms. But then the application paragraph said, to convict, you have to find the intent to arouse or gratify the sexual desire, right?
Yes,
So how could the jury have been misled?
but because of the result language, and the result language was pushed on them several times by the prosecutor. In the prosecutor's charming language, he said, she got off on it, you can check it off your list.
so, but is this a case that where we're addressing an argument that the prosecutor's closing argument was incorrect?
No, Your Honor.
Or is this a jury charge question?
This is a jury charge question.
all right.
But it was, the harm wasn't objected to, but it was exacerbated by by the prosecutor saying, you can take the result into account.
Just to put it in lay terms, is the concern here potentially that in the abstract, the notion of result of could have bled their way into the nature of conduct? So if he intended to be wrestling with her and she happened to be aroused or gratified as a result, that's enough.
That is a reasonable result, a result from the thing.
But,
Whereas I'm sorry, Your Honor.
So an iron-fisted juror could have been pounding that view in the back of the jury room. Is that your concern?
Indeed.
Yeah.
Isn't there, and there's, along that lines though, I mean, there's always that risk. You've got a juror in there who's just very compelling and is misleading the jury down the primrose path. That can happen on just about anything, even if the jury charge is completely accurate in everybody's imagination. Isn't that the case too?
Certainly, Your Honor, but that's what we try to limit in Port R.
Counsel, go back to arguments. If we're talking about the confusion here between intending sexual gratification and potentially convicting based on result sexual gratification, does not the prosecutor's argument again and again and again in opening, in direct, in closing of she got off on this, she got off on this, is that not all focused on the result was she was aroused? She may not have intended the conduct, she may not have intended to be aroused, but the result was she was aroused. Does that not go back to what counsel for the state characterized as the wrong portion of the jury charge and focus the jury there?
Yes, it does.
And what's
It
the ramification
emphasizes
of
the
that?
result. if I understand you correctly, Your Honor, it emphasizes the result.
But
And
the
result-
groping happened over numerous times, right? I mean, this wasn't just like an isolated wrestling incident. This was something that happened over and over again. So the fact that she knew that she would get off on it, doesn't that show that her intent to engage in the conduct for that purpose?
She was convicted of 2 counts, Your Honor. Whether it happened more, it may have, it may not. But
Okay.
if I might be crude, being a junior high school boy means doing something and then getting aroused by it without knowing.
But this is not a junior high school boy.
But
This is a potentially mentally challenged, poor English-speaking woman wrestling with another young girl, which is a common practice in the house.
And which the witnesses testified she has the mind of a 15-year-old. And she didn't admit to it. Yes, it may have happened. She may have been aroused after the fact, twice, 3 times, maybe, and not gone into it with that intent. That may have happened, but that's not good enough. The law requires that be the intent.
Right, and isn't that what the application paragraph requires? It says, with the intent to arouse or gratify, intentionally or knowingly engage in sexual contact.
Yes, so in a sense, that paragraph is in conflict with the application paragraph. And so when the application paragraph is reinforced by the prosecutor saying, you can convict on the result of this conduct. The result is, well, he didn't say this, but the result is this poor 12-year-old girl who became 17 had her breast touched by someone who got off on it after the fact. That is enough to convict. And, Your Honors, I don't mean to blame a child as a victim, but we expect common sense even from 4-year-olds. We teach them you don't just run out in the traffic, you have to look both ways. And we expect that they'll do that when they're outside on their own. This was a 12-year-old. She knew what wrestling was. She was a fan of some female wrestler. If a woman doesn't want, or a girl, doesn't want her breast touched even in sport or play, then wrestling is not a good choice for her. But she did it, she must have known this would be a part of it. Unless she was also intellectually deficient, and there was no indication in the trial court that she was.
Counsel, let me ask you this question.
Yes,
If
sir.
I told you, and when I say if, this is a hypothetical, but if I told you that I agree with young Cook and that the only issue in this case that I think is even a close call is harm, convince me that the error is harmful.
Well, Your Honor, the state provided that by emphasizing to the jury that the result was sufficient to convict. It emphasized it twice. This is, where was I? This is it. This is the result. That's what they said was proper. It wasn't exactly what the application paragraph said, but it was certainly authorized by the abstract paragraph.
And with the objection, we're looking for some harm, which we previously said is any harm.
Precisely.
So what we're looking for here is any harm.
Precisely, Your Honor. The objection was preserved both orally and in writing, and the trial judge said no.
Was that argument by the prosecutor properly characterized as erroneous argument? I mean, was it outside the bounds of proper argument?
I would think so. It wasn't, granted, it was
wasn't
not
a-
objected to with the thing.
So, I mean, how does that impact our, considering that as something that's harmful when, or it demonstrates harm when we otherwise hold that to complain about jury charge error, you have to have objected to it, and there is no objection here, so
There is,
how do we balance these are two different, types of claims, and you're kind of asking us to look at the fact that an error happened that wasn't objected to in order to show harm for one that was objected to? Is that the way we do it? Or-
well, for instance, say that the state had entered evidence that the child was intellectually disabled. No objection is proper to that, but that means harm is reduced because she may not have known that by doing some sort of wrestling, her breasts would be touched. It wouldn't have been objectionable, but it would have been harmful to the defense case. Does that answer your questions?
I think it attempts to. I'm not
Okay.
sure
So
I'm
the-
not sure it satisfies me fully, but,
Okay.
So the counsel, the analogy that keeps coming up the last couple minutes, I feel like your argument is that you bought a coffee table from IKEA, put it together, and there are 3 pieces left over, and you're like, why are there 3 pieces left over? But then the coffee table works for 5 years, so presumably the coffee table was put correct. Like, why is that analogy wrong here? Like, why isn't the issue here that the jury charge provided extra pieces, maybe even provided a piece that shouldn't be in the coffee table kit, but if you follow the instructions, you built a coffee table and it's sturdy. Like, why is that analogy not accurate here?
Because the coffee table, how to put it? The coffee table was, the coffee table wasn't what the jury charge would have predicted. I'm sorry, this is a bad analogy. But
I agree, yes, it's a bad analogy.
You can change under Cook, you can change the abstract instructions or the application paragraph if you timely object. And so you could timely object to somebody putting the coffee table together with 3 parts missing. That doesn't mean that it's going to fall apart in 10 minutes, but it's certainly error. The question is harm. How long is this coffee table going to stand up? I don't know. But if you have pieces left over, it was poorly put together. All we have to do is prove some harm from this, that one time someone set a cup of coffee on the table and it slid off. All we have to do is prove once. We have to prove any harm. That's what Cook says. Cook is definitive. It tells exactly what should happen. We're talking about 40 years of jurisprudence, and Your Honor, it seems to me overruling it would be a judicial nightmare. You're going to be stuck with cases that say, this jury charge was close enough under the new case. No, it wasn't close enough, therefore, you should, it leans on it leans on what is close enough and what wasn't. It might not be definitive.
But we won't be hearing arguments any longer that because the trial court gave the full definition that was provided by the legislature that somehow there was error in the first place. We wouldn't be hearing all those cases if that was the case. If we said, no, give the definition the legislature wrote.
And that
It would have to be a new kind of claim that people would bring, and it would be one suggested by that Judge Campbell's dissenting opinion that would say, is there anything in this jury charge that misled the jury? It seems to me that would be a rather simple inquiry.
If the new case said that, yes. If it said, well, you should put in this, you should put in that would be definitive as well. But there will be lots of arguments against that, such as Judge Campbell's dissent. There will be lots of arguments against that and what is good and what is harmful under the new
Well, if we were to do that, maybe we could make the rule prospective in its application only to avoid the ambush on all the cases tried under Cook.
Indeed, Your Honor. But the second amicus brief filed in this case illustrates the sort of arguments that are going to be made. It said Cook was wrongly decided and should be more in the defendant's favor, and it should be, because 603 wasn't properly written, and so the whole thing should be written again. It should be a different formula. Well, that question wasn't raised below either, so with all due respect to the author, it's not considered
Let me ask one factual question I should know the answer to, but I don't. Was there any text warning the jurors in moving from the abstract to the applications? You may use these definitions only as they are specifically relevant to a term that is defined below in the application.
There was no explicit one, as far as I remember, but it was certainly implicit. Intent means this, knowing means that, therefore,
I mean, that would have reduced some of the speculation, potential speculation about what jurors might have done moving between the abstract and the application, but that wasn't there.
of course, Your Honor. I see my time is expiring. If the court has any questions, I'll be delighted to answer.
Here's not. Thank you.
Thank you all very much.
Would a Campbell rule, would a rule like Judge Campbell's opinion, that like the rule you stated before, would it cause all the problems in the world to happen in the future?
No. I would encourage the court to do this. Now, I do think that if a judge, if a party asks for the full definitions under 603, I think a trial judge should give them. I think that if an attorney wanted from voir dire and in closing arguments to say, this is the legislature's words, here's what it means here, and points to and explains, I think a judge should give that instruction. That's why I don't think it's error in this case. And even if it's not asked for, I think it's a way to do it. There are other options. The state bar pattern jury charge is another option. Intent means conscious, objective, or desire. On that point, the abstract definition of intent says intent can be if it's your conscious, objective, or desire to, including, cause the result. But you still have to have the conscious, objective, or desire to cause the result. If it's your conscious, objective, or desire to cause sexual gratification, the mental state is met. If they follow down that route, we still have the elements of the offense proven. That's why this is not a great case, or it is a great case to illustrate why all of this stuff is not going to be error in the charge. In addition to that, the workability of this. The problem with workability is the difficulty in determining which of these mental states apply. I'm not even sure when you have a specific intent, like with intent to arouse or gratify, it's spelled out, that there really is any tailoring that's meant to be done. Now, the definition for with intent might be if you just have, like, cause the death of a person with intent. That would be a time when you would use a 603 definition to find out what does the element go to. What does that intent go to? But when it's spelled out with intent to arouse or gratify, with intent to defraud, with intent to deceive, like, that is already told to the jury what they need to know. And there isn't any other value done in 603. In that case, when there is only a specific intent, that's the mental state for the offense, which this one may very well be, then there is not additional value, and a judge could decide not to give the 603 definitions at all.
So, counsel, I think in the lower court, the state conceded error, and you're not conceding error, so you kind of switch gears there. Is that correct?
That's right. And the Court of Appeals, as it was supposed to, decided that it would do an independent review and determine if there was error or not.
Okay, so then let me ask you this question too, this, basically the same question. If I told you that I think the only issue that's a close call is harm, convince me that this is not harmful. If there was an error, okay, hypothetically.
For the same reasons.
If it was error.
That the jury charge told them repeatedly you have to have the intent to arouse or gratify at the beginning of the state's argument before they start talking about that, check the box on arouse or gratify. They say, here in the state's charge, the definition of sexual contact requires you to have the intent to arouse or gratify. No one was arguing and pointing them, you don't have to have the intent to arouse or gratify. Everyone accepted that as the truth, as a part of what had to be established, and it was here. That when they talked about knowledge in the charge, in the closing arguments, it was in response to this idea that because of the defendant's deficiencies, did she have the awareness that what she was doing was of a sexual nature? And that is the response why the state was going there, because that's sort of what the evidence of the case was about. It was not about how we might interpret these abstract definitions, and maybe some people are thinking about result and some people are thinking about conduct. That wasn't it at all.
Assume for the moment that in a civil case in this state, that the rules require the court to instruct the jury on with the questions, definitions, and instructions that are raised by the written pleadings and the evidence, that it has to be tailored to the pleadings and to the evidence. That removes the potential for jurors being directed to ideas that are not at issue in the case. Why would we want any greater degree of ambiguity and speculation about what jurors might have been acting on in a criminal case where the due process interests are elevated? Shouldn't we have at least that level of confidence about what jurors were doing?
Because you can have a true statement of law, like what is the offense of murder, and stating that incomplete is a true statement. So even though some bits of it might not apply to that trial at hand, there are often parts of the abstract charge that are true statements, really law, that don't play a part. And while I think it's better that you should narrow it, absolutely, it doesn't mean it's error not to. Even, I think maybe not, it shouldn't be in the civil context either, because you're gonna be narrowing it when you get to what we have as the application paragraph.
One very brief question. Counsel, if there is a path for this jury to convict based on the definitions in the abstract without proof beyond a reasonable doubt of intent to gratify, however small or narrow that path is, why is that not a harm?
Because we would have to assume that the jury didn't listen to anything else that went on. I think that is a possibility, you know, like, in any case, that they
So
could
the
just
possibility of
completely-
wrongful conviction is not a harm?
That is definitely a harm. That's not what I'm saying. I'm saying everything throughout this trial told the jury they had to find intent to arouse or gratify.
Except the jury charge.
Even the jury charge, in multiple places, in section 1, in section 3, and only if they go down a very bizarre path by interpreting 2 in a unusual way would they find anything differently. And I don't even understand how that would be possible, since you still have to have intent to do a result. If you intend sexual gratification, you have, that is the requirement of the statute, whether you think of it as result or conduct. You still have that requirement.
I'm gonna jump on your one last question. Do we accept affidavits from jurors to explain what they were doing during deliberation?
No.
Why not? Because we know we don't want to know the answer. Anything else? Okay, thank you both very much, really enjoyable. We'll stand adjourned until we are not.
Oye,